Is the urgency? There are matters below your matter also. ATN? Who's on the other side? 80 and 81. 82. What is the urgency? What is the urgency? Why should you get precedence over the other matters? Call the list.
Number one. Come to here, 295 of 921.
Yes. Yes.
I got an occasion to go through my lord's one of the judgments. Similar issue was there. I have annexed that judgment also.
Against you or in your favor?
Somewhat in my favor, my lord. So I have included it.
Very well. You have also filed.
But I have also filed my submission.
Very well then. Hearing is concluded, judgment is reserved.
Okay.
Okay.
Very bad one happened.
Item number two. WPN 984 of 2023.
Lordship, medical students matter. Where your lordship, during the pendency of the matter, they have declared, they have been declared passed.
Yes,
So
yes,
they
yes,
have,
yes.
Already attended the classes,
Mhm.
so they may be permitted to participate in the university examination, which is scheduled in August. This is in respect of item number two, your lordship.
Yes.
Item number three, your lordship, one of the petitioner, number one, he doesn't want any order. He wants just simply.
Item number 3, there is only one petitioner. Oh, I see. Yes, what is the instruction?
But whatever the animals will say, if they have passed the examination, then I don't think so they
Let them participate in the examination, sir.
The purpose of writ petition has been completed, so this application has become infructuous. The prayer has been, they have, grievance has been redressed. So this application has to be dismissed as infructuous.
What has been redressed? Prayer.
They pray for that, the result of the exam has to be declared as passed.
That was the scope of the writ petition.
Yes.
Retrospective appreciation of the order.
This was the development. This only was what by way of the interim order permitted me to participate in the internal examination and also permitted me to attend the classes of second year as well as subsequently third year also. Now second year examination is going to be.
Therefore, who is for the authority? Who is appearing? Yeah, well,
But I am for the college. I have run by the rules of the NMC and
We are for
university.
who is going to say, Mrs. Nag? Nobody is saying anything.
I'm saying they are not permitting me to participate in the second year examination, which is scheduled in August. They are saying yes, they are not going to permit. That they are saying.
Where they are saying? Who? They meaning who?
College and university and NMC, all.
Yes, college. You are the college.
I am for the college.
all
Yes.
say.
What is your instruction?
But they are saying ki because Malad, they are first, they have made this writ application that they have to, they are, as per the animus new rules, they have been passed in the examination of first year. Now, Malad, when this writ petition is going on, Malad, they have taken classes of the second year, now second year examination. Now, as per the new
So
rules of
you-
animus, Malad, anims, they are passed in the first year examination.
You are the college, you permitted them to attend the classes of the second year
As per the direction of the court, Malad,
as per direction of the court.
without equities, Malad.
No, it's all right. Nothing stopped you from preferring an appeal against that order of court.
Malad,
So you accepted the order of court.
Malad.
So don't say as per the order of court only. If it was not acceptable to you, you should have assailed that order before a higher forum. You did not. Today, after permitting them to hold classes, attend classes for the entire second year, you say you will not permit them to sit.
That Lordship, but only thing is, my lord, the interim order specifically says no equities will be created at the field. In effect, equity now, but my lord, be that as it may, your lordship.
Participate in the examination, it's not that declaring me pass.
No. In respect of sitting, the order says.
What is the problem in, what is the problem?
Objectively, my lord, my lord, that is for your lordship, my lord. My lord may pass that order, my lord. We
No,
can
that I will.
consent to it.
What I am asking is, you cannot consent, I know. But what is the real problem? Why is
The
the
problem is, my lord, I also oppose this question. So what they are saying is because they were doing two classes at the same time.
Yes,
So one does not know the extent to which they have attended. I mean, even if you have, how can you cram so many classes within a particular period?
that's a
But that, of
speculation.
course, the examination will show whether they
Correct,
learned
correct,
anything or they haven't.
correct.
But my lord, that your lordship will then have to pass that order.
I'll pass an order. Pass an order.
But actually, my lords, in this, the college has very little say. Eventually, it is the university, Mr. Singh's client, who has to.
Mr. Singh says nothing.
And
My
then
lord,
the
my lord,
NMC
may I
which is
submit?
Let him-
The facts of the case is that these candidates have failed in the fourth attempt. Thereafterwards, a notification was issued subsequently. They wanted by virtue of this writ petition that it should be given a retrospective effect. NMC has refused that it cannot be given a retrospective effect. But they have obtained an interim order. By virtue of that interim order, they have attended the classes. Another important development which has taken place.
Now, Mr. Singh, now, you see, the interim order was passed at a point of time, possibly,
Right.
when the first year results had not been declared. Now they have succeeded.
Now it has been declared in the fifth attempt.
Doesn't matter. If the law or the rules permit fifth attempt is easy.
Fifth. Yes, they are passed. But
If they have passed, then why will you not permit them
now,
to sit?
from 8th of March onwards, they have got their own university.
Own?
They have formed their own university in the Andaman Nicobar Islands. Netaji Subhash Chandra University. I am placing it.
No, so what is your, so you have nothing more to say?
We have nothing to do with
He
that.
doesn't have.
Pondicherry University has nothing to
Has
do.
nothing to
Let
do
them
with that.
conduct the examination. We have no problem.
Come, they're done with that.
NMC, my lord, has to. Because we have only.
National Medical Council, who is that?
National Medical Council, my lord.
Yes,
No, this is with regard to the first year exam result.
yes.
The old. Rule
All I am
failed.
saying, let them participate. Since they have passed the first year exam,
Now they have-
let them participate. If they have not studied, they'll fail. I am not directing you to declare them as pass. Hey, they'll come. And then what happens to the writ petition? Disposed of. Read order dated July 31, 2024.
Objection by kindly.
It is not in dispute that the writ petitioner, this is number 2, huh? Writ petitioner has cleared the first year examinations, comma, albeit ALBEIT, in the fifth attempt, which is permitted under the applicable rules. Stop. On the strength of an interim order passed on this writ application, comma, the petitioner says that he attended the second year classes. Stop. The second year examination is scheduled to be held this month. Stop. The petitioner says that the college has said that he will not be permitted, Amir Shah, he or she will not be permitted to sit the examinations. Stop. Paragraph. Learned advocate for the college says that it is not clear whether the petitioner attended the requisite number of classes. Stop. Hence, the college is reluctant to permit the petitioner to participate in the second year examinations. Paragraph. I have also heard learned advocate for
For respondent number 6 and 7, for the Pondicherry industry.
Pondicherry University and National Medical Council.
4 and 5.
Stop. They did not have much to say about the matter. Stop. Paragraph. I am of the view that no prejudice will be caused to anybody if the petitioner is permitted to sit the second year examinations. Stop. Obviously, if she has not studied and prepared herself, comma, she may not succeed. Stop. However, comma, since she says, comma, that she has attended all the second year classes on the strength of this court's interim order, comma, it may not be fair to deprive her of the opportunity of participating in the second year examinations. Paragraph. Accordingly, I direct the respondent authorities to permit the petitioner to participate in the second year examinations, university examinations. Stop. Paragraph. No useful purpose will be served by keeping the writ petition pending. Stop. WP such and such, WP is accordingly disposed of.
Right.
Yes.
My submission may be recorded from 8th March, my lord. 8th March.
Not necessary, Mr.
No, they have declared they have got their own industry.
Very well.
And they have no relation.
Therefore, you have nothing more to say now.
Nothing with the Pondicherry industry.
What is about number 3?
Petitioner number 1, he doesn't want any orders. Simply he is withdrawing.
Withdrawing.
Petitioner number 1,
And the other one?
Same order.
Same order.
For
So
petitioner
number 3, right? এই দুটো petitioner আছে দেখি এখানে লিস্টে একজনের নাম আছে কেন?
petitions.
The learned advocate for the petitioner number 1 says that he or she does not wish to press this writ application. Paragraph. WPA such and such is dismissed for non-prosecution insofar as the petitioner number 1 is concerned. Insofar as the petitioner number 2 is concerned, comma, the order passed today in WPA 984 of 2023, comma, will apply and govern. Now, this is also disposed of.
Right.
There's a can also disposed of, huh?
Sir, I'm appearing item number 4 being led by Ms. Debashish Roy.
Sir, I need to appear online.
Item, yes.
My lord, the defaulter of a bank had tried to, my lord, the defaulter of a bank had tried to impede the bank officials of the bank after losing in DRT proceedings of a criminal proceeding under 420, etc. He moved an application under 156(3). The honored magistrate directed inquiry by the police. Upon receipt of the inquiry report, the learned magistrate dismissed the 156(3) application. Totally suppressing this, he again lodges a complaint, and the police, though had submitted a report that the dispute is purely civil in nature, it's a banking transactions, started an inquiry. Now I gather the police, after re-inquiry, has again filed a report that no cognizance offense has been made out and the matter is purely civil in nature.
Yeah, please.
If my instruction is correct, this application has now become infructuous. But your lordship will kindly reserve my right, if situation so demands, to move your lordship's court again. Because I don't know whether the de facto complaint will move an RIG,
To
whether
156
the
filed for an investigation against you.
Yes.
yes, that was dismissed. That was dismissed by the magistrate.
First time dismissed
First time dismissed, second time no 156(3), straight to the police.
or straight to the police.
And the police starts.
My lord, I am appearing for the respondent number 7, who is the de facto complainant in this matter, my lord. Actually, my lord, the matter is that a regular overdraft loan was going on with the bank. And suddenly a stop statement of mine was used as a sanction application for a temporary OD.
They will not listen to virtually what the court has to say. Why are you dragging the court into all this
In the
now?
opposition, we have stated that after producing necessary documents and completion of re-enquiry, enquiry officer has submitted his report by concluding that no cognizable offence has been made out and the matter is.
End of the matter.
Yes, it is the end of the matter.
End
End
of
of
the,
the matter, but your lordship has seen the uh, vehemence of the learned lawyer for the de facto complaint. Your lordship will kindly reserve my right to come to your lordship's court again if situation demands.
come. You had filed this challenging what?
Initially, I had filed challenging the notice issued by the investigating officer calling me in connection with the subsequent proceeding.
It appears that the investigation that was being conducted or that was proposed to be conducted, there's an interim order of stay, na? Proposed to be conducted, but has been stayed by an interim order of this court.
So investigation,
Investigation.
Oh, I see.
Investigation.
inquiry to continue, but no coercive steps.
No cause. What did I say? Now, that it appears, cancel. It appears that the writ petitioner approached this court challenging a notice issued by the investigating officer calling him to calling him for the purpose of investigation. Stop. However, a report has been filed by the investigating officer that no cognizable offence has been committed by the writ petitioner. Stop. Paragraph, Mr. Debashish Roy, learned senior counsel representing the writ petitioner says that the writ petition has become infructuous. Stop. However, the past conduct of the de facto complainant shows that he is all out to harass the writ petitioner. Stop. Therefore, liberty should be reserved to the writ petitioner to approach this court if the same becomes necessary in future. Stop. The writ petitioner always has such liberty. Paragraph WPA is disposed of.
Grateful, my lord.
Item number 5, WPA 52 of 2020.
But this writ is in the form of O.
Whose appointment have you challenged? Who is he?
Heard, my lord. Private
You
respondent.
have,
This should be issued to.
you have served.
Your lordship.
Where
It
is
should
he?
be heard, lordship. No, private respondent has to. No, they have served with you. I will file the evidence service.
Yes, but this is appearing after quite some time.
I'll give you notice afresh.
You give a notice
Afresh.
listed at my instance.
My
Mr. Jain.
understanding. My understanding.
This is an old matter. Stop. It has been listed at my instance. Stop. Paragraph, let fresh notice of this writ application be served on the private respondent and affidavit of service be filed in court on the next date. When?
Let it come in the next circuit.
Next circuit.
Next
Very
circuit.
well.
Come.
As suggested by Mr. Jaipal, learned advocate for the petitioner, this matter may be placed before the next available circuit bench. As requested, not suggested, as requested.
I'm appealing for number 6, here 13/21. I'm appealing for the respondent, my lord.
Item 6, appellant. No, appellant. He is lovely. Not today. Do you know who is for the appellant, sir?
Well, Mr. Tabrez appearing for the appellant.
Will you have a word with him?
No, I have not seen him.
I will keep it on Thursday.
My lord.
Ajay, better keep it on Thursday. Recorded orders. Nobody appears for the appellant. Stop. The state is represented. This is number 6. 6. Stop. Let this matter be listed once again on give Thursday's date. Paragraph learned advocate for the state is requested to inform learned advocate for the appellant that this matter will be listed again on such and such.
My lord, in the cost settle, my name may be added, corrected.
Yes, please add Mr. Sivabalan's name.
Highly obliged, Your Honor.
Tell Mr. Tabriz.
Item number 7, WPA
Here, why not my learned senior indicated that he gave a copy to us.
I'm giving here now. Lordship, already one of the matter has been disposed of. So these matters, right from item number 7 to 12, can be disposed of in the line of the order which I have just submitted. On the ground of parity of reasoning alone.
My learned senior is saying that it is the same issue, then it can be.
Same issue.
Same. Shatadru appear in that matter also. Yes,
I don't remember. I'm going by your statement.
I'll go with the papers.
Whatever you say.
I'm going with the papers.
I have no memory.
Yes, you did appear.
No, I'm saying I don't recall one of the facts. So, but if my learned senior is making a statement at the bar, I can't come in the way.
Have you received your fees for this matter?
That also. I don't know. It's a direction for consideration of representation, my lord.
In the light of the entitlement recorded by the court. Entitlement has been recorded, no? Their claim and point has been drawn now.
Learned advocate for the petitioner says that another matter being WPA 54 of 2020, involving identical issues, was disposed of by a learned judge of this court by a coordinate bench. Disposed of by a coordinate bench by a judgment and order dated December 15, 2022. Stop. This application may also be disposed of with a similar direction. Paragraph. After hearing learned counsel for the parties, I direct the administration to consider the prayer of the petitioner for denotification in respect of his land and take a final decision in accordance with law after granting opportunity of hearing to the petitioner or his authorized representative. Stop. A reasoned order be passed by the competent officer in the administration within 4 weeks from the date of communication of this order. Stop. Let the final order that will be passed be communicated to the petitioner within a week from the date of the order. WP such and such is disposed of. Separate orders in 7 to 12. Just see, all are men, no problem. No, there's one Prem Kumari. You need this? No.
This is a case where a state deed was submitted before the registration. During the pendency of that, the authority has changed the stamp duty charges. They have enhanced it. It was duly notified by the Lieutenant Governor, the stamp duty, registration charges, and circle bill. All 3 notifications were there. Now, his writ petition was filed challenging all 3 notifications and seeking and direction upon the authority to register the state in terms of the previous stamp duty charges and all. That is the writ petition. Now, another set of writ petitions were filed by some other people, Your Lordship, as a public interest litigation before this honorable court challenging those 3 notifications. Now, that application has been allowed. All three notifications have been quashed.
Then this is becoming infractuous.
No, direction to register the same.
Direction.
That is in prayer.
Well, their prayer is to challenge, my lord, that
Sorry?
the prayer has become infructuous because the same relief has been granted in another writ petition.
No doubt they have to then apply the earlier set of, earlier rate of whatever.
If I recall, my lord, can I just, the writ petition, my lord, the prayer is only for setting.
No, it is there. I will show you. I have gone through that one. Through the judgment day.
आपके पास है लिखा copy?
No, it's a prayer. Specific prayer is there.
You,
There is a prayer, my lord, prayer I is there.
yes.
Mr. Balan is appearing, I am not appearing. He is appearing.
For the registering authority.
Yes.
So there are simple direction since the,
Same order will.
hey. Ure Baba. The writ petitioners had submitted a sale deed for registration before the competent authority. Stop. Prior to completion of the process of registration, comma, the registration charges were enhanced vide notifications issued by the administration.
That
Registration charges and stamp duty were enhanced. Stop. The writ petitioners challenged the same by filing this writ petition. Stop. Paragraph. Several public interest litigations were also filed, challenging the notifications enhancing the registration charges and stamp duty. Stop. By a judgment and order dated May 21, 2024, those writ petitions have been allowed. Stop. The three notifications impugned in those writ petitions were quashed by a division bench of this court. By a judgment and order dated, did I say May 21? No. Yes, I said so. Were quashed by a coordinate bench, by a division bench of this court. Paragraph. In view of the aforesaid, the prayer in this writ petition for quashing of the concerned notifications has become infructuous. Stop. I direct the respondent number three. Respondent number 3 to register the one sale deed or many. The sale deed submitted by the writ petitioners, applying the relevant charges as were prevailing prior to issuance of the three notifications which have since been quashed by this court. Stop. Let such exercise be conducted, completed at an early date and definitely within what is a reasonable period? Tell me, I don't know.
2 months, Your Worship. Registration.
2 months
2 months from the date of
communication.
communication.
of this order to the respondent number 3. Paragraph WPA such and such is disposed of.
Apply. Item number 14, WPA 270 of 2020.
My lord, I am appearing for the petitioner. Last week only I have received the copy of opposition, my lord. I'll be filing my reply.
Reply, how
2 weeks
long?
time. 2 weeks.
2 weeks. Learned advocate for the petitioners says that only last week he received a copy of the affidavit in opposition affirmed by the respondents. So he seeks 2 weeks' time to file reply. Paragraph, let this matter be placed before the next available circuit bench. So in the meantime, let affidavit in reply be filed by the petitioners.
Obliged.
Item number.
My lord, this matter will be somewhat impacted by that matter which your lordship was hearing today when Mr. Banerjee had appeared, my lord. Let it
Right.
just go to the next, let it go to the next circuit, my lord, I request.
On the prayer made on behalf of the appellants,
My lord, may record that since a matter between same parties is pending before.
I said, put it this way. Learned advocate for the appellant says that 2 appeals are pending before the division bench, comma, the decision in which that matter.
Yes, my lord. In fact, a decision in this may impact that or either way, my lord. So it is somewhat interrelated, although not directly here, my lord. This is a civil revision against order of the district judge on the
What did I
injunction.
say? Before the division bench, comma, involving similar issues, stop. The decision in those 2 appeals may have significant impact on this case. Stop. Therefore, comma, this case may be adjourned till the next circuit.
My lords may say may have some impact, my lord. My submission may have
Not significant, some impact.
some, my lord.
Let that be done.
Item number 16.
In this, my lord, I am for the respondent.
My lord, I am for the petitioner, my lord. I pray for next circuit, my lord. As there's a change of the council, my lord, so just because of that.
Very well. Learned advocate for the petitioner says that there has been a change of counsel recently. Stop on her request, comma, let this matter stand adjourned and be listed before the next available circuit bench.
Item number 17, WPA 359 of 2022.
Lordship, I am for the petitioner. With the direction of the authorities to fight the opposition, they have not filed. I think for the 2 years have passed.
Sir, the similar matter. This application is not maintainable, my lord, since the petitioner is not a tenant. His shares he has already sold to another person.
Your Lordship, let it be not today, Your Lordship. I'll take the instruction. If that is the position.
Yes.
Not today.
Obliged.
Item number 18, WPA 864 of 2022.
This, my lord, I am for the respondent number 5 and 6. This petition has become infructuous. Why I say this, my lord? Because
No, why you say that it is a, I would rather hear it from the petitioner.
nobody is representing the petitioner. This is the difficulty I just want to highlight before my lord, since assailing the single bench order, we appear before the honorable division bench.
Let's see what order I pass.
My lord, no.
Nobody represents the petitioner. Stop. Learned advocate for the respondent number
5 and 6.
5 and 6 says that, make this a paragraph, learned advocate. says that this writ petition has become infructuous. Stop. Paragraph lists this matter at the top of the list under the heading for dismissal on such and such tomorrow.
My lord.
Now, if he doesn't come, then I'll dismiss
My lord.
for dismissal within court. Hey,
We can dismiss them.
Item number 19.
Your Lordship, just not today.
not today.
Let a copy be given to him.
Item number 20. CO 17 of 2024.
Your Lordship, in this matter, my senior Mr. Arul Prashant appears for the writ petition, Your Lordship. I'm praying for crossover,
Crossover.
20 and 21.
My lord, 21, my lord, I am praying for an interim order. My lord, from day one, I try to move this application.
Just pass over, Your Lordship.
Crossover.
I'm obliged.
Item number 22. CO 27 of 2024.
Item number 22, my lord, not for today.
Crossover.
Not for today.
Not today.
Item number 23. WPS 348 of 2024.
My lord, in this matter, I am for the writ petitioner, my lord.
I'm for the private respondent, some of the private respondent.
Have you filed your affidavit of service?
Yes, my lord, I had filed. It was verified.
All the respondents have been
Yes.
served.
Yes, all the respondents have been served.
You have checked that yourself.
Yes, yes, ma'am.
I'm relying on your statement, sir.
Yes, my lord, I had filed also.
Very well.
Yes, ma'am. My lord, the writ petition is that, my lord. In terms of a will, Revenue Authority had mutated the revenue records in favor of the private respondents without giving an opportunity of hearing, and for that
Where are the official respondents?
official respondent.
Miss
Babita
Babita.
Das.
Huh?
Miss Babita. used
Babita
to
Das
attend.
was appeared.
Madam, my senior is appearing for official response.
Yes.
Please for short passing in the
Crossover.
Item number 24. WPS 352 of 2024.
Lord, demolition order has been passed by the Port Blair Municipal Council. That needs to be implemented, my lordship. For which the service has been effected, my lordship.
Affidavit of service? Affidavit of service আছে?
No, it has not been filed. I can file.
Tomorrow file it. Simple matter.
My lord.
Not today.
Item number 25. WPS 356 of 2024.
Your Honor, in this matter, my senior is appearing for official respondent.
Crossover.
So this can be by way of an affidavit, lordship, has to be decided.
Oh.
An order has been passed by the Deputy Commissioner North and Middle Andaman, rejecting my claim for
Oh.
regularization.
What claim? Monetary claim?
Regularization of a land.
Regularization. Learned advocate for the petitioners says that in this writ petition, under challenge is an order of the Deputy Commissioner,
My lord. North and Middle Andaman.
North and Middle, rejecting the petitioner's apostrophe claim for regularization of a plot of land.
Yes.
Stop. Paragraph. This writ petition should be decided after exchange of affidavits. Stop. Let affidavit in opposition be filed within 4 weeks from date. Give the date. Stop. Reply thereto, if any be filed within a week thereafter, within 2 weeks.
Well,
Within 2 weeks thereafter, list the matter after 6 weeks before the then available circuit bench.
Item number 26. WPS 387 of 2024.
the same order by the same authority but of South Andaman district.
This is South Andaman, Deputy Commissioner, South Andaman.
My lord,
Same order.
my lord.
And here there is only one petitioner, huh?
Item number 27, WPA 992 of 2023. Item number 28, CRA 12 of 2024.
Your Lordship, in this particular matter, Mohammed Sabri sir appearing behalf of the petitioner. This matter can be fixed on next circuit because he is suffering from food poisoning, Your Lordship.
Oh. On the prayer made on behalf of the petitioner, on health ground of learned advocate, comma, let this matter stand adjourned and be listed before the next available circuit bench.
Your Lordship. Obliged.
Item number 20, CO 20 of 2024.
Your Lordship, in this matter, my senior Mr. Arul Prashant appears for the writ petition, not today, Your Lordship.
Not
My lord.
today.
Unobliged.
This is that matter, my lord. Pass over matter, my lord.
No.
20 bola.
29.
29.
My lord, in this matter, Mrs. Nag is appearing for the respondent.
Which one?
29, item number 29.
20.
Note.
Item number 30,
In
CRA 20.
In this, my lord, I am for the state CBI.
Your Lordship, in
Same that, health ground.
33.
Up
Next
to
circuit.
33. Up to 33. There are
Oh, up to 33, same.
33.
Next circuit.
Yes, my lord. Twenty-eight, these.
Item number 34, WPA 216 of 2024.
Pass over.
Item number 35, WPA 365 of 2024.
These are electricity
And
connection.
for the petitioner, my lord. Usual matter?
My lord,
Let's
this
see.
is not usual, this is something unusual. I am placing certain documents with my lords, for my lord's perusal. All these petitions pertains to, all these petition right from 35 to 48 pertains to Austin 2.
So Mohanpur.
Mohanpur, Austin 2.
Mohanpur,
Austin
RV.
2, Diglipur. The revenue department says there is no revenue village as such.
There is no?
Revenue village as such. And it is a forest department, it says that it is a reserve forest. Now, kindly have a look at page 8, my lord.
No, then Mr. Lal,
My
it's a
lord.
serious thing. My lord.
My lord,
What you
here,
do,
here I will suggest Mr. Satadru appears for the forest department. Since the forest department, this is forest land, kindly have a look at the
My lord.
page 8 given to my lord.
My lord,
Affidavits are false affidavits. It's
My-
no,
yes, what?
My lord, my small submission, my lord. The same village, Mohanpur RV, is the revenue village assigned by the revenue department. And according to my application, kindly come to my affidavit, my lord, where I have submit. Accordingly, the order may be passed. My lord, this is totally a revenue village. As such, I have filed
this is
the
the,
petition.
this is the letter of the forest department. This is their land, reserve forest.
This is Mohanpur RV. And my lord, one thing very importantly,
It is here.
Mr. Chakraborty, I will ask Mr. Chakraborty, he appears for the forest department.
more importantly, my lord, the similar order have been passed in the same village. Because this is Mohanpur RV in survey number is
Where
specified.
similar order? Show us similar order.
The last circuit, my lord. I have
This is in relation to.
Show us that same village order has been
My
passed.
lord, this is.
My lord, I may give a time, my lord.
Without ascertaining.
given
it was
time, my lord.
ascertained. Without ascertaining the fact the
If
magnanimity.
it is not a revenue village, no
It's
electricity.
not revenue village, my lord.
Then no electricity connection
My
can be given.
Governance case is there, certain restrictions are there, riders are there, it's not free. It's for Mr. Satadru to say in the matter. And in the earlier petition also,
My
they
lord.
added,
My lord, I have one copy, the previous
is-
circuit, my lord.
this is in
Same
relation,
village, my lord.
This is in relation to that only, my lord. When we inspected, we found, and this is the observation.
My lord, my small submission, my lord, electricity main wire is going through my roof, my lord. And I am deprived from the electricity for the last so many years, my lord. And this is the constitutional matter, my lord. As such, I am deeply praying before my lord, kindly.
Sir, this is official document saying there is no revenue village
My lord.
in the name of Austin 2
And this
under jurisdiction of Mayabandha Tehsil.
I have mentioned, my lord, Mohanpur RB. This is Mohanpur, this is the Mohanpur.
petition, what is mentioned. And there is a letter of the forest department. 26P is a forest reserve. forest.
Mohanpur Tehsil.
Mohanpur is the revenue village, my lord.
Revenue village.
Under this Austin 2, I may be not right Austin 2. Maybe it not be considered, just right, I will go through the Mohanpur village.
Document.
If it is not specified in the revenue. My lord, kindly come to the petition, my lord.
I'm not following. Mr. Lal, you are confusing me more than anybody.
My lord.
We are concerned with Mohanpur village.
My lord,
My lord.
my lord.
This is
You are saying, you are showing me document which shows Austin 2 is a reserve forest.
kindly. Kindly see. Kindly go through. This is 26P, my lord. The referred to document referred to the forest department is 26P.
Show me Mohanpur village is not a revenue village. Where do you show that from?
This is the document, my lord.
Nowhere it mentions Mohanpur.
He mentions in the petition, this is in Austin 2. Mohanpur is in Austin 2. In all his petitions. Rest, kindly see at page
My lord,
2.
Mohanpur is revenue village. Mohanpur is revenue village. That's as I have coding. And
Mohanpur you have said is in Austin 2.
No, yes.
Austin
Yes,
2.
madam. Mohanpur village is the revenue village. That my application I have filed.
Please try to understand, sir. Mohanpur village, according to you, is a revenue village.
My lord, my lord,
According to you, Mohanpur village is in Austin 2.
my lord.
Austin 2 is a forest area.
I don't know, my lord.
That is the report. That is what we are trying to say. That is the official report.
My submission, my lord, I have
For that, we need a counsel from the administration.
Forest department, Mrs. Satadu.
my lord, my small prayer, my lord. I may be considered as a revenue village of Mohanpur. Accordingly, I am deprived from the last so many years, my lord.
There's no mention.
And sir, and my lord,
Mr. Lal,
But for forest department, we generally appear.
you appear.
This is the reserve forest land.
Sir, why let us do this?
My lord,
Let me dispose this off by saying
my lord,
you process the application.
my lord.
And unless there is any specific bar in law,
my lord,
you will provide electric supply.
my lord.
My lord, what is to,
Now
my
that
lord?
is also not acceptable to
My
you.
lord, one line, my lord. Kindly go through the records, my lord.
No, I will not. Tell me why is this not acceptable to you?
My lord,
We
in-
are
my
reserving
lord,
entire.
it is a remote island, the remote area, there is no line at
What
present.
did I tell you?
At present,
Unless there is any bar in law
my lord,
and unless there are very good reasons.
my lord, we will.
This is an application, no.
And on the
No.
other side, the compliance of the all other requirement of.
Of course,
code,
that is
my-
of course there. The writ petitioner raised for a direction on the respondent authorities to provide electricity connection to the writ petitioner's house at the located at the place mentioned in the writ petition. Paragraph. Learned advocate for the respondent number 1. Respondents, you appear for both the respondents.
I appear for the
Respondents.
respondents.
Respondents says that the cancel the second paragraph. Say, having heard learned counsel for the parties, comma, Again cancel. It is now settled law that an occupant of a property is entitled to electricity connection irrespective of his status in law insofar as his occupation is concerned. Stop. One may refer to the full bench judgment in the case of special bench.
Abhimanyu Majumdar.
Abhimanyu. Huh? Reported at such and such. Find out the citation, na? Stop. Paragraph. Accordingly, comma, I dispose of this writ petition by directing the respondents to process the writ petitioner's application for electricity connection and provide such connection unless there is some bar in law or there are some other compelling reasons
Well.
for not allowing the application for electricity connection, comma, subject to the writ petitioner complying with all necessary formalities. Stop. The exercise should be completed within a period of
8 weeks. 8 weeks. This Hamlet's.
8 weeks.
in-
8 weeks from date.
Well.
Date. Same order in all the applications.
My lord. Deeply good.
Like,
Item, item number 49, review 2 of 2024.
This matter, I am for the review petition in this matter, my lord, but I am praying for a short passover because this matter we are saying, my lord, that due to presentation of false and fabricated document by the, my lord, respondent, right now respondent, my lord, there are some orders are passed by this honorable court. And my lord, we have to prove that those documents are false and fabricated and those were not produced, the original documents were not in the record.
So
before.
how will Passover improve the situation? In the second call, you will be able to prove.
No, the documents are not annexed here too, but Mr. Chakraborty, since he is on the panel, why he is here.
Passover.
Okay.
I will be writing a little early today, so may not
Fine,
be.
no problem, my lord.
Item number 50, CPM 35 of 2024.
I appear for the petitioner in this matter.
First time.
First time, Your Lordship, the contempt application.
Whose order?
Point.
Habera. This contempt application has been filed alleging willful violation of an order passed by another learned judge of this court, within bracket, Hiranmay Bhattacharya ji. Stop. Paragraph accordingly, comma, let this matter stand released from my list and be placed before the appropriate bench.
Item number 50 on WPA 397 of 2022.
Yes, practically hearing was concluded. This is that case when junior engineer, my lord, who was working on contract basis for more than 11 years. On some allegation that after some bills were passed, he was removed from service without assigning any reason. And I have cited judgment and my lord has asked him whether there is any law or that principle of natural justice would not
Mr.
be applicable.
Chakraborty was arguing.
My lord. A reason, my lord, it seems that reasons are not been given, my lord.
Nothing.
No reasons are.
So hold an inquiry, and take a decision.
My lord,
Where is that order of termination?
after giving them a proper
My lord,
chance of
page
hearing.
57.
Page
57.
Okay, 46 was the show cause.
So called.
Then your reply was page 48.
And improved order is at page 57.
Correct. The writ petitioner just say the petitioner. The petitioner challenges an order dated May 31, 2022, whereby his service as junior engineer civil bracket closed was terminated by the administration. Paragraph. The petitioner was engaged as junior engineer bracket civil on contract basis in the year
In the year 2011, on the basis of a selection process.
in the year 2011, on the basis of a selection process, a full-fledged selection process. Stop. On September 17, 2021, a show cause notice was issued to him on the basis of alleged administrative lapses on his part. Stop. As called for, he filed his reply to the show cause notice on October 8, 2021. Stop. Paragraph. The petitioner says that after he filed his reply, there was complete silence on the part of the administration. Stop. He continued with his service. Stop. He obviously thought that the matter has been set at rest. Paragraph. Suddenly, by an order dated May 31, 2022, issued by the Assistant Director, bracket administration, bracket closed, the petitioner's service was terminated with immediate effect. Stop. Hence this writ petition. Paragraph. I have heard learned counsel for the parties at some length. Stop. No disciplinary proceeding was held against the petitioner. Stop. No opportunity of hearing was granted to the petitioner. Stop. The order terminating the petitioner's service does not indicate even briefly as to why the petitioner's reply to the show cause notice was insufficient. Stop. He will not be able to hear me. Stop. In my considered view, the principles of natural justice have been flagrantly violated in the facts of the present case. Paragraph. It was sought to be argued feebly, FWBLY, on the part of the administration, that since the petitioner is a contractual employee, he cannot claim that employee, principles of natural justice would not apply to him. Stop. I am not in agreement with such contention. Stop. Particularly when an employee is being sought to be terminated on the basis of allegations which would amount to a stigma, comma, such employee must be granted a reasonable opportunity of defending himself. Stop. Paragraph. Without going into the merits of the case, comma, only on the basis that principles of natural justice have been breached by the administration, comma, I set aside the termination order dated May 31, 2022. Stop. The administration will be at liberty to hold such proceedings against the petitioner as they may be advised and conclude such proceedings observing the principles of natural justice, comma, in accordance with law. Disposed of. Set aside, the consequence is therefore that. Set aside, where set aside, stop. The consequently, comma, the petitioner stands reinstated in service.
Item number 52, WPA 1030, flat 23.
Mr.
Mrs. Nagi is
Yes.
appearing for. Let the matter is not today.
Not today.
Item number 53, WPA 915 of 2023, with item number 54.
I am appearing for the petition.
But I am for the respondent in the matter. Ms. Nagas filed her affidavit in reply in the second matter, which is item number 54, which is tagged. Today she has filed, so my lord, we have to go through that reply. My lord.
Not today.
Well,
Day after tomorrow.
Day after tomorrow.
Item number 55, WPA 236 of 2018.
My lord, let this be, because this will be decided, one matter my lord has reserved for judgment. On the other day, we have submitted, what would be the fate? The same will govern in this matter.
Single bench.
Single. Similar matters. So,
Very well. Learned advocates for the parties say that another matter involving similar points was heard by this court and judgment has been reserved in that matter. Stop. It would be helpful if this matter is taken up after judgment is pronounced in that other matter. Paragraph as suggested, comma, let this matter stand adjourned and be placed before the next available circuit bench.
Item number 56, WPA 327.
next circuit.
56.
Yes. Yes.
You are the
I am the petitioner.
on the request made on behalf of the writ petitioners, comma, let this matter stand adjourned and be listed before the next available circuit bench.
Item number 57, WPA 119 of 2020.
my lord, I am appearing for the petition. Mr. Balan seems Mr. Balan is appearing in this matter for us, but he is on his legs before bench number 2 with Mr.
Pass over.
Item number 40, item number 58, WPA 46 of 2021.
This matter becomes infructuous, my lord, although they are.
My lord, in this matter, Mrs. Nagi is appearing for the petitioner, my lordship, that the same may be withdrawn, your lordship,
As such, the
One-
prayer of the very petition is itself is infractious.
Infractious?
Your Lordship.
Very well. Learned advocate for the, give your name, madam, take the appearance. Advocate for the, which one is this?
Item 58, my lord.
Petitioners, learned advocate for the petitioners says that this matter has become infractious. Stop. As requested, comma, now. She has instructions to withdraw this writ petition. Paragraph WPA such and such is dismissed as withdrawn. Stop. Interim order, if any, comma, stands vacated.
Stephen.
Item number 59,
59.
WPA 178 of 2021.
My lord, I am appearing for the petition, my lord. There was a direction upon the respondents to file their affidavit in opposition.
Not filed.
Not filed.
But this matter is also my lord, a sort of infractious matter
It is
because
not infractious.
this Nag is for the private respondent, I am for only for the government exercise authority.
Last date also, my lord, direction was given upon them to file affidavit in opposition.
Not this circuit.
No, not in this circuit.
Time was extended on 12th April.
Perhaps thereafter.
Then we have to file, my lord. We will file, my lord.
You will file.
My lord.
Private respondent is also there, Mrs. Nag.
Because civil case is going on in between them. There's just a liquor matter, the small matter.
Not.
On the request made on behalf of the respondents, comma, time to file affidavit in opposition is extended peremptorily
My lord.
by 2 weeks from date.
Great.
Stop reply thereto, comma, if any, be filed within a week thereafter, Mr. Vendakumar.
My lord.
Paragraph lists this matter after 3 weeks before the then available circuit bench. Hey, what to the board?
Item number 60, CRR 23 of 2022.
Your Lordship, in this matter, Advocate Siddharth Sinha is appearing for the petitioner. Due to some personal difficulties, he prayed next circuit.
Next circuit, on the request made, on the prayer made on behalf of the petitioner, comma, let this matter stand adjourned and be listed before the next
Much-
available circuit bench.
Item number 61,
Give your name, madam.
WPA 77 of 2022.
I am appearing for respondent, madam.
Your Lordship, in this matter, Mr. K. Sabir is appearing for petitioner, Your Honor. He's pray for not today, Your
Not
Lordship.
today.
Sir,
Item number
Obliged.
62, WPA 180 of 2022.
My lord, let it be taken in the next circuit.
Next circuit.
My lord.
On the prayer made on behalf of the petitioner, comma, let this matter stand adjourned and be listed before the next available circuit bench.
Item number 63, WPA 240 of 2022.
I am for the respondent, madam.
You are for the petitioner? Same order on the prayer made on behalf of the petitioner?
Obliged, madam.
Item number 64, WPA 4 on 7 of 2022.
My lord, let it be in the next circuit.
Same order, next circuit.
Item number 65,
I am appearing for the respondent.
Mrs. Nag is appearing for the petitioner. Matter maybe it's not today. Your Honor.
Not today.
item number 66, CRR 26 of 2023.
My lord, in this matter, there is an interim order, my lord. Lastly, when it was extended up to in the month of June, perhaps on 18th, my lord. So it was there up to 18th of July. My lord, thereafter, actually, the matter was not listed and I also did not inform the court, my lord. So 66, my lord.
Is there a board somewhere from where you can see the item number?
Here.
Yes, my lord.
There should be a board so that everybody can see what item.
Outside the door, it's there, man. just
Yes.
outside the door. It is there.
In the principal bench, we have one inside the courtroom also, so that the judges can also follow. বুঝতে পারছো কি বলছি? করে দিত, হ্যাঁ, ওইটার সঙ্গে কানেকশন করে দেবে। হ্যাঁ, बाहर में जो दिखाएगा वो अंदर में भी दिखाएगा।
Lastly, it was extended on perhaps on 18th June, my lord, for another 30 days. And thereafter, my lord, after 18th July, it was never listed, it was never called.
Shall continue till 15th June.
No, thereafter, there is an order, I think.
Not in the file.
My lord.
Oh, yes, there is.
Well-
There is. On the 18th of June. Yes, for further 30 days.
My lord, thereafter, actually, I was here, but I did not mention it, my lord.
Very well. Now, what do you do with the matter? You will have it.
Let it be in the next circuit, my lord. It's a criminal appeal.
An interim order was operating in this matter. Stop. On April 9, 2024, the interim order was directed to continue till June 15, 2024. Stop. On June 18, 2024, the interim order was extended for a further period of 30 days or until further order, whichever was earlier. Paragraph. Accordingly, it seems that the interim order expired by a flux of time on July 18, 2024. Stop. Paragraph. The state is there.
I'm there.
Very well. Let the interim order stand reinstated and continue till the end of September, 2024, or until further order, whichever is earlier. Paragraph. On the requests made on behalf of the parties, let this matter stand adjourned and be listed before the next available circuit bench.
Obliged.
Item number 67.
My lord, I am appealing for the petition. Let it be in the next circuit.
With that, one of those orders on the prayer made on behalf of the petition.
68 and 69 also may be the next circuit.
67, 68, 69.
Yes, well, I am for the respondent one.
Yes.
Item number 70. WPS 757 of 2023.
Just not today, my lord. Here I am seeking only the interest, my lord.
Not today.
Not today. एक बार फाइल देख के आता हूँ, फाइल देखने।
Item number 71.
क्या रखा है सर?
WPA 863 of 2023.
करेंगे।
I am agreeing for the respondent. I am seeking extension of time to file opposition.
How long?
2 weeks.
First extension or how many extensions?
Not first extension. Last extension. This is the last extension.
Direction for filing affidavits was given on December 12, 2023. Stop. Thereafter, extension of time to file affidavit in opposition was granted on January 9, 2024, March 12, 2024, June 12, 2024, and July 4, 2024. So, paragraph. Today again, a prayer is made for extension of time to file affidavit in opposition. Stop. As a last chance, Time to file affidavit in opposition is extended by 2 weeks from date. Stop. Reply thereto, if any, we file within 2 weeks thereafter.
Highly obliged.
Paragraph lists the matter after 4 weeks before the then available circuit bench. Somewhere, right, nobody appears for the petitioner.
Item number 72, WPA 883 of 2023.
My lord, 14 June order may be seen. There is a direction to the appellate authority to dispose of the appeal. That period is already over. The appellate authority is sleeping over the matter. And there is a direction upon the private respondent to serve copy of the appeal also. That was also not served. Only to defeat the writ petition, this tactics was followed by the private respondent.
My lord, in this matter, Mrs. Nag is appearing for the private respondents. I pray for a short passover, Your Honor.
You take instruction not today. Take instruction regarding non-compliance.
Status of the.
Yes.
No, I have not received a copy of the notice.
14 June, there was a clear order. The appellate authority is directed to dispose of the appeal within 4 weeks and to communicate the order to both the parties.
Second page may be seen, my lord, thereafter. Please see.
Yes.
Copy was also not served till date.
Copy of the appeal has not been served.
My lord.
Anyway, come back tomorrow. This instruction he has to take. Huh?
Similar matter lots passed on order 2 days before.
Yes, yes. I know.
Now they should notice fixing tomorrow is the date.
Come back tomorrow. Because I did pass a very strong order in some other
It's a
matter.
contempt, my lord, clear case of contempt.
I am not passing any such order.
Illegal construction, they are going on making construction, the authority is sleeping.
Not today.
Item number 73, WPA 886.
Look, sure. Let this order come. By an order dated June 14.
June 14.
2024, the appellate authority was directed to dispose of the appeal within 4 weeks from that date. Stop. Paragraph, Mr. Prashant, learned advocate for the petitioner, says that he has not received any notice from the appellate authority.
Nor the copy of the appeal was served.
Copy of the appeal papers was served on him as was directed by the earlier order.
Well.
Stop. Paragraph, Mr. Chakraborty, learned advocate for the administration, says that he will obtain instructions and come back tomorrow. Paragraph lists this matter under the heading for orders tomorrow at the top.
Oblige.
Item 73, WPA 887 of 2023.
Your Lordship, in this particular matter, Mohammed Tarus sir is appearing behalf of the petitioner.
Next circuit.
Your Lordship.
Remember, there were other orders. Held the ground.
Oblige, Your Lordship.
Item number 74, WPA 894 of 2023.
My lord, I am appearing for the private respondent.
In this matter, Mrs. Nag is appearing for the petitioner, not today, ma'am.
Not today.
Item number 75, WPA 907 of 2023.
I am appearing for the respondent. It is day after tomorrow, my lord.
Day after tomorrow.
Item number 36, WPA 978 of 2023.
Your Lordship, in this matter, Mr. K. Savi is appearing. I am praying for not today.
Not today. Not today.
Item number 77, WPA 106.
Lord, this matter may be taken up, my lord. Today or tomorrow, my lord.
As you say.
I am out of service, my lord. This.
If you think it will conclude today, then take it up or tomorrow.
Formal.
Hey.
I'm grateful.
Item number 78, CRA AP on 2024.
I am for the respondent, my lord.
Crossover.
Number 79, WPSP plus 2024. Item number 80, WPS 68 of 2024.
Satisfied and maintainable. Made my mind, is my lord. My audible, my lord.
Audible, not visible. This is item 80.
Yes.
Ordinary part.
My lord, I am audible, my lord.
Yes.
My lord, what made my mind bright today is, my lord. My lord has considered a similar facts and circumstances today and passed a necessary order in item number 51. Similar facts and circumstances which I am agreed to. Is basic principle of natural justice has been violated. Contract employment, you are serving for the last 6 years.
That was an autonomous body. This is administrative.
I can't remember. Then let this be not today. That order will be available by tomorrow. I can't remember what order I passed in 51. So come back tomorrow, please.
Lordship, in the similar facts and circumstances, Lordship, a termination order has been set aside by your Lordship in item number 51, where it was a contractual employment without serving a show cause notice, without giving me an opportunity of being heard. My application was not considered even, representations was not considered even. I was terminated all of a sudden, Lordship.
Yes.
Although the fact is, Lordship, I am serving for the last 7 years. My contractual employment has been renewed from time to time for the last 7 years. As and when I was taken into custody in a criminal case, my ground shown for termination was that a criminal case is pending against me. Contractual employment has been seized. That is the reason I have been.
Sir, your voice is breaking. It's not possible to have hearing like this.
Yes.
Where is he? He's in Calcutta. Where is he? You are his.
Lordship. Am I audible, Lordship?
At times you are, at times you are not.
Lordship, a similar facts and circumstances which has been determined by your Lordship.
I have heard, come back tomorrow. Let us see what that order
Lordship,
be.
kindly Lordship fixes it to on the top of the list, Lordship.
Let it be. Not possible. Amongst the first 10 items, give it. Amongst the first 10 items.
Lordship, amongst the first in the list, Lordship.
Mr. Chakraborty, if no kind of opportunity was granted, my views are maybe wrong, but some opportunity has to be granted. Look into it, come back tomorrow. Look into that order also, it should be, I don't know.
Lordship, similar facts and circumstances that made my mind bright today, Lordship. That made my mind bright. Similar facts and circumstances, contractual employment, termination, without giving opportunity of hearing.
Oblige, my lord.
I am grateful, my lord. I am grateful.
Next circuit, health ground, yes. Sir, come, yes.
Item number 82, WPA 184 of 2024. Item number 83, WPA 224.
Your Lordship, I am for the petitioner. Here, Your Lordship, the petitioner has applied for the post of draftsman grade 3 in the Portman Municipal Council. Draftsman grade 3.
Draftsman.
Yes, grade 3 under the Portman Municipal Council. Now, Your Lordship, the qualification prescribed in the recruitment tool was 2-year certificate course. But this petitioner, both the petitioners, they are having 3 years certificate course. That is 3 years diploma in civil engineering. these petitioners. Now, Your Lordship, in 2005, similar issue cropped up. The Central Administrative Tribunal has given a direction to the authorities that you have to form an expert committee and find out whether 3 years diploma in civil engineering is equivalent to 2 year certificate course or not. They obtained in this material from the expert, that is the Government Polytechnic College, and they have specified that the 3 years diploma in civil engineering is much higher than the 2 year certificate, because entire syllabus of 2 year certificate is included in 3 years diploma engineering. It's more advanced. On the basis of that, employment has also been given to one of the candidates at that relevant point of time. So my submission is that they have materials with them, expert report is there with them, then also they are not allowing me to participate in the trade test. What happened? I submitted application. When application advertisement was published, I submitted application. They allowed me to participate in the written examination. Written examination was over, my name was there. Thereafter, they shortlisted the candidates, and my name was also there in the shortlisting, that notification or merit list what they have published. There also my name appeared. And when I went to participate in the trade test, they said, no, we are not going to allow you to participate in the trade test because you are not qualified in terms of the recruitment rule. But the situation, all materials are there. Expert body report is there.
Before I hear Mr. Chakraborty, you see, the qualifications and the criteria, these are within the exclusive domain of the employee recruiting authority.
Yes, Your Lordship.
If the conditions of recruitment said that plus, what is it, 2 year?
2 year certificate course.
Certificate course or its equivalent, then you would have had a fantastic argument.
Your Lordship, this
That is
particular
not
issue
there.
was already decided. The authorities have their expert report.
Report is to what effect? That this is at least as good or even better.
The entire syllabus of 2 year certificate course is included in the 3 years diploma in civil engineering. That they have said.
What do you say?
You have my proposition.
I'll come back on it tomorrow.
Come back tomorrow. Come back tomorrow.
Item number 84, WPA 205 of.
My lord, here also, my lord, this petitioner worked for more than 15 or 20 years. One fine day, he was thrown out of service without giving any opportunity of hearing.
Yes.
15 or 20 years, my lord, I will. Let it be upgraded, my lord, so that similar.
তুলে দাও এবার প্রথম 5টা ভেতর দিয়ে দাও
Item number 85, WPA 243 of 2024. Item number 86, WPA 266 of 2024.
And a lot of this one. Petition.
Man, provision is there.
Not today, my lord. Kali hard it tomorrow, my lord. Get from.
এই পাস ওভার ম্যাটার দেখো যে
कितना नंबर है मेरा 56 मेरा ऊपर है मेरा 20
Bill number 20, and for you 17 of 2024.
पहले उसका है क्या
I find the suit. Before the minute 4 kilometer. Page 9. This is copy of the suit. Before the that find. Page 10, very similar. Suit for permanent injunction restraining the defendants from using unrestricted name of Mazid. This is my suit. Now, my lord, kindly see the registration certificate. I am not claiming any property from the one board. Use the official name. That is my prayer before the current court below. Court below dismissed my suit holding that you have not issued any notice to the one board. It is not written. I fail to understand, my lord. Kindly come to page 78.
So what is this Masjid Noor? What is this?
Name.
Of what?
Masjid.
Of a masjid.
Registered name is something else.
Huh?
Registered name before the authority is something else.
Something.
Registration certificate, page 8078.
And who are you?
I'm one of the worshipper of that masjid. You are using unofficial name. I approve the work code. Page 78, what's it called? Kindly see. The bylaws approved by the court for rendering proper and better administration to the work, Masjid al Noor. This is the original name under the registration certificate. Pongicham hereby enforced with immediate effect. Kindly see date of registration 4th July 2016.
You appear for the defendants in the suit.
My lord,
Defendants in the suit. You are for?
the work code, my lord. Before my.
Please wait.
My lord,
Please wait.
this, after this dismissal, the dismissal was on the ground, statutory notice was.
That's not required.
Now, after that, what my learned friend done? Learned friend issued a statutory notice and thereafter he filed one more case. Where an interim order was passed, that is the subject matter of challenge which I have filed. Practically, this case doesn't survive.
No.
For academic.
I have not challenged the work board property. I asked the
What is
authorities.
your subsequent action?
My lord, the maintainability on that maintainability ground, it was dismissed. I challenged that.
I am told you have filed another case.
In that also, interim order was passed.
That interim order was challenged.
That case is for what?
My lord, same.
Relief.
Then how you will file, you will proceed with two.
One application, my lord, this order passed by the court below is not maintainable. This order was passed first, and interim order was granted first.
You have already filed a second application. No, that's not. I will not allow you to do that.
Lord,
You have chosen to file a fresh proceeding.
yes,
You have abandoned this. You have accepted the order. How can you proceed with both?
I filed fresh suit after that, not before. Kindly see the registered name. What is registered name? 78. I am not challenged. I am not asked any property from.
Let us see the order here, which you are on the challenge.
This order is absolutely illegal, my lord. Page 120. I am not challenging the work property.
I will vacate the interim order in the second matter then.
If this is allowed, my lord, I will not prove the suit.
Really? Let us see.
89 notice, my lord, comes only when I claim a property in the work.
What is 89? I don't know. Work of fact.
Work of fact.
Hey, then. Work of fact, that's it.
I have not prayed for any property. I say that use the correct name in terms of the registration certificate. Practically suit is not against the work board. Practically suit against the ad hoc committee. Ad hoc committee illegally using the name.
Yes, Mr. Vindukumar, why should an 89 notice be necessary at all?
My lord, section 83, my lord.
83.
83.
is Constitution of Tribunal.
Yes, my lord. It says, Constitution of Tribunal as anything fit for the determination of any dispute, my lord. Any dispute, penal or other matter relating to a work or work property, eviction of a tenant or any dispute.
I am not raising any dispute with the work board. The ad hoc committee was appointed on my application. The ad hoc committee is misusing the name. My prayer is innocuous, absolutely innocuous. My suit may be seen, my lord.
Oh, so look, the learned civil judge junior division dismissed the proceeding suit on the ground of lack of notice under section 89.
My lord,
Section 83 is something totally different.
my lord,
It is the forum.
my lord.
It is the forum. It is one thing to say that the civil judge doesn't have jurisdiction.
Civil judge passed the order as a work
I
tribunal.
mean, what tribunal?
Well,
Very
what
good.
tribunal?
Then where is the 89? The Waqf is not involved as such. No relief is claimed against the Waqf.
Yes, your relief was claimed against the Waqf. I will place, my lord. I will place.
Relief is claimed, the Waqf is against the
My
different
lord, the
relief.
Waqf Act, under the Waqf Act, the Waqf board passed an order. My lord, there was several embezzlement in the said committee.
The defendants are the members of the Waqf board.
No,
No.
we were appointed as an ad hoc committee by the Waqf board. They are chairman board. I am letter. I will show my lord that letter where the name of the masjid is written as Masjid Nur. No, we have no interest in the said work for what the registration certificate is appointed.
My lord, since it is my application, my lord, I may be permitted to.
Very well, easy.
I did not claim even an inch from the work board. My prayer is innocuous in nature. Use the correct name, official name. That's all.
Yes.
The board is not a party.
Board is a party. Oh, board is a party.
Board is a party.
Board is a party. But my claim is not against the work board. I am not claiming any property. My prayer is innocuous in nature. On the basis of the registration certificate, use the correct name. That's all.
If board is a party, you will have to give
Yes,
notice.
the board is a party and section 89 subclause specifically.
Board is a party because they are the registering authority. I am not claiming any relief.
Doesn't matter, sir.
My lord, I am not praying any relief against the work board. My only prayer is use the correct name. That's all.
8912.
Where other committee has got nothing to do with the registration certificate. Let them show there is a registration certificate in favor of Masjid Nur. Bylaws is there. I am out of the court.
Yes,
Well, page 78 is the registration certificate.
we have seen that.
No, my lord, page 79. My lord.
Yes,
79, my lord, will find second line. Name of the masjid. Masjid Nur,
yes.
Quarry Hill. Now, my lord, I lodged complaint, written complaint. Kindly come to my lord, page 27. Your lordship will find Masjid Nur. As per the registration certificate, this marriage was, nikah was performed, a certificate was issued.
Yes.
Kindly see the date, my lord. 15th September, third line. 15th September 2020.
Whose marriage is this?
This is one party's marriage.
Yes.
I want to show that they issued certificate in the registered name, Masjid Nur.
Yes, very well.
Page 27.
Yes.
Now, my lord, page 23. Page 23.
Yes.
Page 23 is the first application. I made it before the work board. Request for constitutional ad hoc committee for conducting election and also for auditing the accounts of Masjid Nur. My lord, kindly take a note. Masjid situated at Phoenix Bay, Port Blair.
Yes.
Based on my application, my lord, a ad hoc committee was appointed, page 25.
Yes.
Page 25, my lord, this is the letter addressed by the work board.
Kindly see, my lord, to the secretary Masjid Enur. Enur, where from they got it, I fail to understand, my lord. In the registration certificate, it is Masjid Nur. My claim is use the correct name, that's all. I am not claiming any property, nor any tenancy right, nothing. Now, my lord, page 75. Ad hoc committee was appointed, my lord, for 3 months.
Yes.
There is embezzlement of masjid's money. I will lodge a complaint. FIR was chalked out under 420, 409, 34 IPC.
Yes.
Page 75, my lord. That is pending.
Yes.
Now, my lord, kindly see 105. One 104 may be seen first, my lord.
Yes.
104, my lords, you will find the photograph. Kindly see, my lord, name. Without any authority, the ad hoc committee, next page, change the name. There is no election, no amendment of bylaws. The ad hoc committee changed the name, not the work board. Initially, I filed the suit, injunction order was granted. Now the ad hoc committee, my lord, they issued forms for membership form. Now kindly see that form first. They say that it is Masjid in Enur, page 30. Page 30 is to be compared with the original form in with the bylaws. Page 30, my lord, got it, my lord? Page 30. This was issued by Masjid, the ad hoc committee.
Why are you taking me into all these? We are on maintainability, whether section 89 notice is necessary or not.
My lord, I issued a notice, my lord, on 7/8. Based on that only, the ad hoc committee was constituted.
Section 89 notice, that was.
Section 89. I am not clear.
The issue 89 notice is necessary or not necessary?
My respectful submission is not required. Not
I heard that. Let me now hear, Mr.
Only one document I
Are you issuing merits, embezzlement of fund? I am not concerned.
That was prior to that. That's why the committee was constituted. Page 99 may be seen, last document. This is the original form.
Yes.
Original form they have to issue Masjid Nur. The ad hoc committee issued page 30.
Yes.
But I am not claiming anything from the work board. Ad hoc committee, why ad hoc committee using unregistered name?
Yes, Mr. Venu.
My lord, the only issue is, my lord, so far as this case is concerned, my lord, whether statutory notice is required or not.
Mr. Bindu Kumar, read 89 carefully.
My lord.
Notice is necessary where a suit is instituted against the board.
Yes.
In respect of an act.
Yes.
Purporting to be done by it in pursuance of the act.
My lord. My lord.
Or of any rules, regulations, etc. Stating the cause of action. Now, here there is no cause of action against the board.
Yes, against the board only. No. Against the board only, my lord.
Where is the plaint?
Yes, I am just placing, my lord. I am just placing the document which was the basis of filing this case. My lord.
No. Show me the plaint.
Plaint I have shown, my lord, page 9. A prayer is page 12. They should not use the unregistered name. That's all. That is my prayer. It is not against the work board. It is practically against the ad hoc committee. My lord, para 14. My lord, please. Para 14, everything is clear. Let me finish. You there are problem. I am not claiming anything from the work board. Use the correct name. That is my innocuous prayer, my lord.
When did your cause of action arise?
When I submitted a representation,
Look at para 14.
my lord. Audit committee,
Mr. Prashant.
my lord.
And further cause of action arose when the defendant number one appointed ad hoc
Audit committee. I'm not claiming anything from the work day. The ad hoc committee, my lord. Kindly appreciate, my lord.
This is your averment in your claim.
My lord, I'm not claiming anything.
Doesn't matter. Doesn't matter. You are making an allegation.
My lord, my respectful submission is
No.
use the correct name.
Do it after serving a notice.
My lord, that was done. That was done. Stay was granted. They will challenge that order also. The second one.
Yes, of course, they are entitled to challenge.
Challenge.
Yes.
They can challenge.
Yes. So we will dismiss this and then we'll take that up. Let us see. You already have an order in your favor.
Not press this application.
Don't press. Who's asking you to press?
No, if you will not see in my favor, then I will not take the second.
No, I'm not inclined to. That's what I'm saying.
My lord, enough was prior only. My lord, I'm not claiming any property from the
Technicalities, sir. Please understand. If defendant number one was not there, or if you did not make that averment in your claim, your cause of action you say is against the defendant number one also.
The prayer is not.
Doesn't matter. Decide what you do.
I'll come back tomorrow.
Hey, keep this at the top. Heard learned counsel for the parties at length. Top, list this matter on tomorrow.
Second one also, my lord.
At the top of the hearing list. Hearing list. Which is the other one?
Item number 21.
Next one.
Next one.
21, keep it. You don't write. It's a tick for it 21 to the other way.